Live and we are right on time. Welcome to another episode of Surviving the Survivor. We bring you the best guests in all of true crime. And we are covering now the Alex Murdaugh trial. Some people are going to yell and say, hey, you're pronouncing that wrong. That is, in fact, the southern way to pronounce it. So you'll be hearing me say Alex Murdaugh. Now, he is, as you know, a once well-respected attorney from South Carolina's Low Country. His father, his grandfather, his great-grandfather were all prosecutors in Colleton County, South Carolina. But now Murdaugh is on trial for the murder of his wife and son. And that is just a fraction of the story. I found this great quote today. There's 1,000 rabbit holes, and there's a rabbit in every one of them, said Mark Tinsley, a lawyer who is suing Mr. Murdaugh in the boat crash case, which we will get to. He had a lot of balls in the air that he was juggling, and I'm convinced that there are things that we still don't know, which we might find out over the course of this trial. Now, it is important to note that a portrait of Murdaugh's grandfather, Randolph Buster Murdaugh Jr., who served as 14th Circuit solicitor for 46 years. So was basically the DA in this county for almost a half a century. They removed his painting, the portrait, from the courthouse at the beginning of this trial. Here to break it all down, one familiar face, one is new. The one that is new with a grizzled beard, which I love, is Dan Walbolt Jr. He is a veteran trial strategist and jury consultant. He is founder and CEO of Best Evidence, which is a jury consulting firm of choice for law firms and many others. They are called upon to play a trusted role in high stakes and high profile cases, including bet the company litigation and other matters with fundamental consequences for their clients. The familiar face is R. Timothy Jansen, the famed criminal defense attorney. He also spent 5 years as a federal prosecutor. And as I was speaking to Tim, and by the way, Patricia Burns says Tim Jansen has great hair. Yes, he does. Getting better with every show. Tim wrote this to me about this case, about the Alex Murdaugh case. It even has a cousin Eddie witness for the prosecution. I love that. This will be an extraordinary trial and a law school class expose dissecting a modern murder trial in the true South with a respected jurist handling the circus, a modern version of the Scopes monkey trial with a highly charismatic and successful defense lawyer versus the reliable white-collar prosecutor. This will be exciting. Tim, to you first, even though Dan will be the star of this show, I think. Do you stand by those comments? Do you think this is, in fact, going to be the trial of the century in South Carolina?
Oh, I believe it is. You're putting up a family. It's a small community, maybe 55,000 people. The family, the grandfather's portrait was the main prosecutor there. The father, he was a lawyer. You got like 3 or 4 dead bodies. And you got a lawyer on trial. You got everything you could possibly want. Addiction, you got fraud, you got theft, and you got evidentiary issues that the defense is really going to be able to make some hay with.
So just to break this down, Alex Murdaugh is accused of murdering both his wife, Maggie, 52, their son, Paul. Basically, his life unraveled over the past 2 years. He was disbarred. He never fought his disbarment or giving up his law license. He did admit to financial mistakes. Overall, there are 100 criminal charges that he's facing. This is a very, on the one hand, straightforward murder trial, and on the other hand, completely convoluted with so many different offshoots to the case, which we will get into over time. I just don't want to overwhelm STS Nation right off the top. One thing he is adamantly denied is murdering both his wife and youngest son. They were shot multiple times at the family's estate, not in the main part of the house, but as I understand it, in another section of the estate back in June 2021. He claims he is not the killer. 2 different weapons were used, and now it's going to be up to 12 jurors to decide if they agree. So Dan, to you, first and most obvious question, how critical is this stage of the trial where they are choosing the 12 jurors?
Well, I mean, it's I don't want to say the most important, but it's the most important that's in front of them right now. Who ends up on this jury is going to have a big, it's going to have a big impact on the dynamic of the jury. So yeah, that's 100% of the focus right now is trying to get this jury picked.
And Dan, questions coming right out of the gates here from Patricia Burns. Dan Walbold, why don't we have professional jurors instead of any old Tom, Dick, and Harriet?
Well, Tim might have a better answer than me for this, but I think the idea is you don't want courtroom sophistication. You want Tom, Dick, and Harriet. That's the whole idea of our judicial system is built on that. Is you don't want professional jurors. So you always try to avoid, and I think in particular in a case like this, my concern, I don't know if Jim agrees, but my biggest concern on trying to pick a jury in a case like this is usually you're worried with people trying to lie to get off the jury. They don't want to sit on jury. And in a case like this, you got to worry about people lying to get on the jury, and what kind of motivations they have and the impact that might have. That'd be not my number one concern, with this jury.
Dan, I think when we were talking earlier, I apologize for interrupting. You were saying this is such a high profile case. If you're one of the 12 jurors on this case, you're potentially getting a book deal with, 6 figures or whatever behind it. So there are people who might have intentions that aren't just constitutional in nature, right?
Yeah, and it might even be not, I'm going to write a book about it, but this will give me something to talk about, forever. So I just think it's something that a lot of people want to be a part of. People are obviously, there's a lot of interest in it. We're here talking about it. So that's just my number one concern. You got to be very wary of jurors that have a, I would say almost a perverse interest in the legal system. And, nobody should want to be on this jury. Really, this is going to be many weeks of not doing what you would normally do in your life and being away from your family. I don't know if they've decided to sequester them or not, but that's obviously consideration. So, finding somebody that's doing it purely out of duty, you almost want to have some reluctance. I think anybody that's too eager, I would be immediately concerned with, at least from the defense perspective.
And Cammie Burchett, thank you. You are echoing my 8-year-old daughter's sentiments to please subscribe and hit that like button right now to get our algorithm cooking here. Tim, this question from Tay Pasternak is for you because you would be the defense attorney if you were in South Carolina. What would the perfect juror look like for the defense?
Well, you'd hire someone like Dan, and you'd give Dan the issues and the facts, and then you come up with a juror profile. And certain people, certain occupations lead people to be certain sway in a jury. Like Dan says, you're looking to keep the person that wants to be on the jury because they're being on that jury if they got a motive. They have a reason they want to get on that jury. And when you're picking a jury, you can tell by their answers. Are they trying to give you the perfect answer? Are they giving you answers that might kick them off? Are they giving you the perfect answer? Are they not responding? Those are the ones you got to really talk to. The ones that normally open up and give you good and bad, or the guy that's trying to get off the jury is the one you want probably on the jury. A 3-week trial, you're probably going to get a lot of retired people because people can't take that much time off of work, and the courts will probably let them off. So really you have to see, and your defense, I don't know the defense's case. You got to know who your experts are going to come in. And if it's going to be basically a science expert, you might want someone with science training and background.
And Tim, do you think this goes 3 weeks or does it go longer?
It's a small town. It's like 45,000 people. Everybody knows about the case. They've heard about it. It's not whether you've heard about the case. The only question is, can you be fair? Regardless of what you heard or what you believe, can you be fair and render a fair verdict? That'll get you through to make you an eligible juror. These trials, depending on the cross-examination, it could take longer than 3 weeks.
It seems like it's going to be longer, and I know, nothing from nothing, but my legal perspective, I feel like it will go longer. Now, this is interesting. In South Carolina, the judge is the only one who can question the potential jurors. That's different than some other states where lawyers can directly ask questions during jury selection. In South Carolina, the lawyers submit the questions to the judge to ask. Tim, that's not the case in Florida, I assume, and would it be difficult for you to operate that way?
Well, Dan and I were talking about this this morning. That's how it is in federal court. You can submit the questions to the judge and the judge asks them. And then most times the federal judge will give a generic question and move on. And all that preparation is for naught. State of Florida, you get to answer questions. And I can tell you this jury in Florida could take a week to pick because you can individually ask each juror and respond. But federal courts, Dan will tell you, judge told us we had 1 hour to pick our jury after the questioning. 1 hour.
So Dan, is that the reason behind it, is to make the process move much faster and we won't sit here for a week? And with that, I'll also tag on another question. When do you expect this jury to be seated, Dan?
In cases like this, it's been my experience that the judge wants to sort of establish dominance early and let everybody know that this is my courtroom, it's going to be my rules. And one of the ways you do that is by keeping everything on track. So if it were up to us and if it were up to Tim and I and we were there, it would take us probably 3 weeks to do jury selection. The judge just isn't going to let that happen. The judge is going to, my guess is going to keep tight control over the courtroom, tight control over the time frame. And, I think it's to the detriment of the defense, quite frankly. I think the judges want to try to ram these things through, and they're very, very concerned about the jurors. We don't want to inconvenience the jurors. We want to try to not waste their time. And so, that leads to, putting the pedal to the metal and basically cruising through. I mean, you shouldn't have jurors qualified at this point, in my opinion. It's just not. I read through some of the basic transcripts of what they had. They haven't done anything yet. I mean, there's nothing been accomplished yet. But that, just from the judge's perspective, we're going to keep going. We're going to keep going. We're going to keep going. So I expect the judge to give no real opportunity for the lawyers to do any kind of voir dire, not really spend any time on the questions that the judges even gave the judge. It's the judge's discretion, right? They don't have to ask any of them. And just try to find it as basic and quick as possible. Can you be fair? As Tim said, that's all I care about. Can you put aside what you think you've heard, and can you be fair? If so, then you're a potential juror, and we'll go on from there.
Dan, let's go through some of the facts from today's start of jury selection. It obviously began this morning. Prosecutors and defense attorneys sifted through some 700 summons, trying to find these 12 jurors and several alternates. More than 200 people were brought in for a first round of questioning. That lasted about 3 hours. Only 30 of those 200 qualified for the pool of potential jurors. They faced a battery of questions, including whether they knew any of the nearly 200 law officers, friends, bankers, and others on the witness list. I imagine it's got to be really tough. Tim just alluded to this small town in the low country in South Carolina, a little county. How difficult, I imagine it's going to be next to impossible to find people that don't know about the case or don't know someone on that 200-person list. So how complicated does this jury selection become, at least from your standpoint as a defense consultant?
Well, I just don't think the judge is going to let it get out of hand is what I'm trying to say. I just think the judge is going to keep tight control over the ship and do the questioning. And again, as Tim said, the question is not, have you heard about it? The question is, have you formed an opinion? And if so, if you've made up your mind, if you prejudged the case, then, you should be excused for cause and we'll go on to the next person. It really, I think from a judge's perspective, doesn't have to be any more than that. Obviously Tim and I would disagree, and everybody on the defense side would disagree, and says you have to inquire about all kinds of different things. Yes, jurors, how they, even just the hardship stuff is not as trivial as just going through and saying, can you do it for 3 weeks and can you get paid and whatnot? There may be somebody who requested, for instance, a hardship and said, well, I can't do 3 weeks. And that hardship was denied by the court because they didn't find it reasonable. And so now you have a juror that's sitting there who's eligible, but they don't want to be there. They're angry. They think they have a hardship. The court has denied. So now they're mad, and you're not even aware of it. Right? If these people had been qualified, maybe in a jury room or something, not in the presence of counsel, it almost sounded to me like that when I was reading some of that some of this happened, in a big jury room outside of the courtroom, as sort of a pre-screen, if you will, or a triage of these jurors. So, if that's the case, that gives me a lot of concern. I know Tim would always want to be there. I'd want to be present for every single question that was done, even that first pass that may seem like it's no big deal. I'd like to know everybody that, that was rejected, that that thought they had a hardship and still made it through.
And Dan, what part of your job is selecting jurors and what part of it is psychologist?
Well, I'm not a psychologist by training at all, so I don't give any sort of attention to the psychology of any of it. It's just simple journeyman social science research. It's if you want to know,
social science might be a better word, but I mean, you're looking obviously for the best juror for your client, which is typically a defense attorney. But are you trying to read them? That's what I'm getting at. I mean, when they're in the courtroom, you trying to read them psychologically at all, or no?
Well, ideally you go in there knowing what you're looking for. You go in there knowing this is the type of juror I want. You want to have a heuristic in your mind, a sort of a rule, a picture, a thumbnail of the type of jurors. Do I want big picture thinkers, or do I want detail oriented people? Do I want people that are conspiracy theorists or people that are not? Do I want trusting people or skeptical people? You don't want to guess at that stuff. You want to know, based on my case, my facts, my venue, this is the type of person that I want. And more importantly, the type of person that I don't want. That's the number one main thing, is who are the rats that I need to identify and get rid of. So you want to have a discrete and distinct picture of the types of jurors you want before you even go in there. And that's what Tim alluded to. That's what the testing is for. You go out and you test. You ask jurors. You tell them a thumbnail. This is what happened in this case. What do you think? And you find the jurors that are, very antagonistic to you, that hate your client, hate your case, and you try to see what do they have in common. And so you want to go in there with a picture in your mind, like I said, or at least some sort of a gestalt of the types of juror characteristics you're looking for. And then when you're in the courtroom, for me, and particularly in a town like this, we were talking about where you're concerned about people wanting to get on this for the fame and the opportunity. I wouldn't be analyzing the jurors, but I would definitely have somebody, it would be their job to be watching them. And particularly I'd be looking for people who were on either extreme of sort of the eye contact with the defendant. So I don't want people that are overly, just watching every single kind of move that he's doing. And nor do I want the people that are going out of their way to sort of to not look at him. So those are the types of people I'm looking for probably in that type of a case. Again, I don't know the facts of this case. I don't know the types of jurors that they're looking for based on their facts, but I would bet you anything it's going to come down to what are the types of jurors that react well to him, to the actual defendant, to Murdaugh. There's some people that, upon just looking at a picture of him, I've seen many people refer to him as creepy. That scares me. That's almost about the worst thing that you can be called. It's just there's a vibe there. You don't want to be creepy. And I understand that he gives that vibe off. So how people react to him, that's testing. That's just trying to find out the people that respond well to him and feel sympathetic to him. And so that's it from the sort of the psychoanalyst side.
It's an amazing amount of strategy that goes into this. Mary quite contrary writes, he robbed millions from his clients, tried to cover up his son's boating mishap. It goes on and on. That is just a fraction of it. And over the course of this trial, we will delve into all of it. Tim, Miss Tree 4058 says the ideal juror would be a black female gay. From your defense standpoint, do you buy that or not? And then we'll get Dan's take on this.
Well, let me say, in big cases where you have a jury consultant high profile, you would do a mock trial, okay? And you would do a mock trial, and you would do more than one. And then you would, and Dan and I have done this, you would figure out who's voting for you, who's voting against you. So you get an idea of either its sex, age, or whatever. Could be financial, could be religious. You know what is good for you, you know what's bad for you, or at least in the mock trials. And so when you're going in there, the first goal is to get rid of the bad eggs. You got to identify the bad eggs, and you mark them on your little sheet because you only get a certain amount of strikes. So you got to make sure you get those bad eggs out. And then a black female, I don't know about gay, but minorities are usually pretty good for the defense because they question the authority. They don't take a deputy or police officer's testimony as given. So that could be right.
This comment here from Patricia Burns, he killed and robbed his housekeeper. Talk about corrupt entitlement. Her name was, I believe, Gloria Satterfield. That'll come up as well. She had fallen down the stairs, cracked her head, died later on at a hospital. But after Murdaugh was arrested for the double homicide of his wife and son, they revisited this case. There was life insurance that was supposed to be doled out to the housekeeper's family. And instead, it looked like it was directed back towards Alex Murdaugh, and that all raised eyebrows as well. This person, Beverly Bilbrey's missing teeth. My mother was called for a juror, but she is 68, and he was her attorney and neighbor. That's obviously going to rule you out here. Dan, according to what happened today, jurors were asked to identify themselves if they have formed opinions on the Murdaugh case that cannot be changed despite what is said in the courtroom. And then several jurors were excused. So, I mean,
but several of them were kept who said they had already formed opinions. Several of them are still there. That's what I said. I mean, there's nothing's been done. I mean, that's just. I think there were 9 of them who said that they had made up their mind and that it couldn't be changed, and those people were excused. But to me, to have anybody who says they've made up they've made a decision about this case, they should be gone without any other further ado.
So how is it possible that they are still there at this point?
the judge is, cracking the whip, and I mean, listen. If you're the judge, you're trying to keep this thing on track, and you're trying to keep this thing on the rails. You just can't get distracted. You can't. You have to keep going, and just kind of almost figure it out later. I'm just telling you, I would bet you one of the judge's first focuses is staying on track with the schedule. There's just almost nothing more important to the judge than that, which is frustrating, right? When you're on the defense, because you're like, this is important, this matters, we need to get this right. Let's take the time to get this right. To have a jury of our peers, and to give the defendant the right to inquire and ask them about how they make decisions, and how, ask them about things to determine their fitness to serve. I just don't think they're going to get a chance to do that.
I mean, Tim, you were on the other side as a federal prosecutor.
Right.
So, I mean, how stressful is it when you don't have the time that you feel you need in this jury selection process?
It's really difficult, because jury selection is almost as important as anything in the trial. You could have a great case and make good arguments in cross-examination, but if you got 12 conservative friends with deputies and their friends, and they're going to vote guilty. I remember I had a really high-profile case in 2000, and it was a federal trial, and they moved the trial. We got to change a venue in federal court, which is almost unheard of. And I asked the judge, can we ask the jurors if they heard anything? He said, nobody's heard about this case, I'm sure. Raised their hands. 90% of the jurors raised their hands. And then I said, well, Judge, if they've heard something, I want to do an individual voir dire with these people, because I'm concerned there was a racial element to it. And I said, Judge, I have the right to do it individually so I don't taint the rest of the panel. He was so mad at me that I did that. I gave him the case law, and we had a minority jury come up, and I said, well, what do you think? Oh, he's guilty as shit. And I said, Judge, I'm moving for cause. He was so mad at me. But if we'd have done the jury selection the way it's being done now, I may never have found that out, and that juror might have been on the jury.
It's another point to make, is that it's one of the things that I think is really just patently unfair about it, is that jurors are going to answer a judge differently than they're going to answer an attorney. And typically what these judges do is they ask for people to volunteer. So the judge will say something like, does anyone have any reason they feel like they can't be fair? Well, who wants to say to a judge, oh, me? I mean, it's, the sort of the social proof, everything is just towards, just don't say anything,
Right.
And I can't tell you how many trials I've seen. I'll reverse it. I've never seen a group of jurors actively participate in a voir dire that was done by a judge.
No,
ever. There's just
Okay.
no.
Yeah, that's
There's just
interesting.
no participation.
Is South Carolina among the minority? I mean, in most states, is it the defense that, gets to question the jurors?
in state court, my understanding that is.
In
Not in
state
federal
court.
court. Yeah.
Okay. So Marie Hernandez here, and Dan, this goes right back to you. How can you trust a potential juror isn't lying during jury selection? I mean, you kind of spoke to it through eye contact or no eye contact. And that was kind of the essence of my question. I probably asked it in the wrong way, but you've got to kind of read the potential jurors, right?
Well, again, I'm less concerned about whether somebody's lying and more concerned about what is their motivation for lying. If they're lying to get off the jury, I want them gone. I want to facilitate that process and see them to the door. If they're lying to get on the jury, that's more important to me than the lying part. So I think the important thing is, and this is why I think it's important for us to ask questions versus a judge, is that we craft questions in a way that we eliminate socially desirable answers. That's a part of being good at jury selection is sort of letting jurors warm up to you and getting some resonance going so that they will participate and share and are honest. you shouldn't be asking them really, I don't think, any questions that they need to lie about. You know, I'm not sure most people really understand what the voir dire process is like, the jury selection process is like, but I can't imagine many questions that, you know, somebody would, again, absent trying to get off the jury or trying to get on the jury specifically, I can't imagine what would be the purpose of, you know, lying as a juror.
Hey, Joel, I can tell you, I had a trial when I was a federal prosecutor in Panama City, and we were prosecuting a very popular doctor for Medicare fraud. And they had pickets up and they had fish fries for free Freddie Williams. And so we're picking the jury. And back in those days, the federal judge, this judge allowed the prosecutor to ask a few questions. And I had a juror I was concerned about because she wasn't answering questions. She was trying to stay, like, hide in the jury box. You know, Dan, you know, the ones that try to hide, get behind people and never answer anything. And so I asked her a question. Do you know Freddie, Dr. Williams? And she goes, yes, he's my doctor. And she never volunteered that information because that would have made, and I said to the judge, we have a challenge for cause because if he's convicted, you'll have to get a new doctor. So the judge excused her. As soon as he excused her, she took off her shirt and she had the free Freddie Williams t-shirt on. She was one of those that was out there for Freddie.
Wow.
And only because I asked that question did I get that response.
Wow. And if you didn't answer it, you think there's a chance you would have sat in your jury?
And I would have probably got a hung jury.
Wow. Wow.
Well,
wow.
we didn't get a hung jury. Too bad for Freddie.
Well, this is what you're going to end up in this case. You're going to end up with the jurors that actually make it through are going to be the ones that don't talk.
That's right.
That's my guess. They're going to be the people that don't say anything to get stricken. And so that's you know, it's one of the things that, you know, they have the saying that the devil you know is better than devil you don't. And that's really the problem. And that's why I don't do much work in federal courts, because I don't think I can really bring much value to that process. You know, if the judges are going to control that process and the judges aren't going to give you the opportunity to inquire, you know, I'm not sure how much I can help there. You're just going to end up asking me to look at a juror who hasn't said anything and say, is this person good for me or not? And absent, you know, case specific data, I'm not going to know the answer to that.
You know, judges don't like jury consultants.
No.
And when we had Dan, we didn't even tell him he was a jury consultant. We said he's an assistant with us. Wow. Because they don't like jury consultants. You know, they think you're playing a game. They think you're trying to squeeze out with jurors.
Manipulate.
And they believe that the truth should come out. 12 normal people can decide a case.
And so if you tell a judge that you've hired Dan as a jury consultant, what is the reaction? Do they have is there any legal recourse on their part?
They can make him not sit by the table. And make him sit in the audience, which makes it really difficult. It's not like that TV show, you know, Bull, where they got the guy. That doesn't happen in real life. It does not happen.
But Dan seems like a nice guy. I'd let him in. Sharon writes, choice of jury today. Judge asked, for those who heard of Alex Murdaugh, please stand. Everyone stood up. Again, back to you. I mean, is it a good sign? Because it seems like there's honesty there, at least.
Well, you know, again, I don't know the specific facts of the case. So it may be better for him to stay in this venue. It may be better for him to go to a place where people don't know him. I don't know the specifics of it in order to say. But again, whether anybody knows him or knows his name is generally irrelevant in terms of their determining their fitness to serve. It's the next question that comes after that. You know, it's not, do you know the person? It's what do you think of them? You know, that's what, you know, what's really important.
Lindsay Shea writes, love that you're switching up the cases, Joel. Also a huge fan of Tim. Love his point of views. Who's not a fan of Tim's? He's the next Alec Baldwin. I said it last night. He's going to go from defense lawyer to movie star from here. This comment, we've got, Dan, back to you. Anita Reyes, can they get jurors from other counties without, you know, a change of venue?
No.
Not happening, right?
No.
And Tim, it doesn't seem like there's any way that they would change the venue here unless there was some kind of deadlock at finding a jury, right? Which doesn't appear that is possible for that to happen because the judge, once again, as Dan said, is running the show, right, Tim?
Under Florida law, you have to try to seat a jury. And, with the Markell case, as you know, it's garnered a lot of attention. We've had 3 or 4 trials already, and they still are able to get a jury. Now, I don't know what South Carolina, but it doesn't seem like the defense wants to change the venue, because the defense is probably hoping that maybe that family, they're going to find someone on that family that can hold out and get a hung jury. So they probably didn't want to change the venue.
This next one comes from Karen Mooring. I served, she's responding to imperfect. I served on a multiple homicide jury in Columbia, South Carolina, and the judge wouldn't excuse a man who had surgery scheduled. Hardcore. So, Dan, I mean, this goes to your point that the judges run the show in South Carolina, and it sounds like this is going full speed ahead no matter what.
Yeah, and I mean, just think for yourself. You don't have to be a jury consultant to be able to see that a guy who has surgery scheduled and is told that that's not a good excuse and he's going to have to sit on this trial. Do you want him as your juror? I mean, he may be technically, he may fit the criteria as being eligible for jury duty, but I don't think that guy can carry out his duty. That guy's going to be pissed. That guy's, again, I just shake my head at that. But yeah, I mean, that's the way it is. That's the judges get a great deal of discretion when it comes to that.
And they don't want, you don't want a juror that doesn't want to be there, because then, the prosecution calls their witnesses and they try to get on and off as quickly as possible. The defense is going to try to put holes in the story. So you want to get them on there. You want to trip them up. You want to cross-examine them. And if that juror doesn't want to be there and that juror just sees you asking questions and not getting anywhere, they blame you for them being there. They blame you for making them sit there and get their $20 a day fee. So it hurts the defense to have a juror that doesn't want to be there.
Leftina 2010 writes, I love jury duty. Dan, would this raise your eyebrows if you were choosing her potentially as a juror?
It's funny. I think I would say probably almost 90% of the juries that I've assisted on picking, one of the lawyers will say just at the end, almost as a joke, does anybody want to sit on this jury? Almost as a sort of a ha ha ha, we're all commiserating together. And I was doing a trial, and I actually had a woman raise her hand and said that she wanted to do it. And everybody, it was almost a rhetorical question. Nobody wants to sit on jury duty, right? And this woman said that she wanted to be on jury duty. And so, yeah, we ended up striking her. Yeah. But it's because it's people have it's interesting. It's why podcasts like this are interesting to people. They're interested in crime and drama and how many lawyer shows have there been on TV over the years? I mean, these cases are interesting, and they're almost kind of like soap opera-ish. So yeah, they're going to draw your sort of the macabre attention.
Yeah. Well, the thumbnail that I chose for this inaugural episode of covering the Murdaugh trial is Stranger Than Fiction. I mean, if you read this story and I gave you a movie script, you'd say you're like over the top. Would you agree with that, Tim? I mean, this is really sensational and insane on so many levels.
There's so many moving pieces in here. And looking at this question from Sharona is an excellent question. And
let me read that out loud for the people who are listening. How do you think Alex's defense team will explain away the high velocity blood spatter near the collar of his shirt? He can't keep claiming he got that by checking their pulses. It's high velocity in all caps. So just to let people know, he claims he was out when his wife and son were shot helping his ailing mother, and said he only got blood on his shirt because he was coming to their aid when he got home. But there is this high velocity blood spatter, as Sharona so astutely points out. Tim, you're the defense attorney. What do you argue?
I'm doing just like they did. They've already filed a motion to exclude the blood spatter. They filed a motion to exclude Bevel, the expert, because they can't say it's human blood. And so what you're going to find out is they filed a motion to exclude it. And like 3 days ago, the prosecution filed a supplemental discovery having a detective or deputy who tested it come out there and parrot the same thing that the other expert wasn't going to be able to testify. So what the defense did was they had what's called a hemotrace test done, and it tests strictly for human blood. They tested that shirt 12 times, and 12 times they were unable to prove that any of that material in that shirt was blood, human blood. If it's not human blood, it doesn't matter how that blood or what spatter it is. If it's not human, it's not relevant. It could have been animal blood. But if it's not human blood, then it couldn't be the human blood of the victims. So they have filed another motion to exclude it under the basis of 403. It's not going to help a jury. It's only going to confuse them. And if you can't tell it's human blood, it should not be relevant. It's going to be interesting to see. And that officer probably cannot give that opinion because the defense never got a chance to test it because apparently they lost the shirt.
Yeah. Yeah.
That's insane. I didn't know that part of it. So is your guess that it does not get admitted into evidence?
Well, this is going to be one where the judge is going to have to do a 403 analysis and maybe say, I'm going to give you great leeway on cross-examination. But if I'm the defense, I'm like, no, judge, this is reversible error to bring this in. That's can completely confuse the juror. They're going to hear it's blood spatter, and it's not even human blood. And if the state can't prove it's human blood, how can they say it's relevant? They really can't if that's not human blood.
You are listening to a veteran criminal defense attorney right there. You've got me wondering now. Smashley writes, the father is part of the good old boys club. Just to reiterate, Alex Murdaugh's father, grandfather, great-grandfather were all prosecutors in this county. We talked about it a little off the top, Dan, but again, how problematic is that in trying to get a jury that is impartial?
How problematic is that he's well known in the small area? Yeah. Well, again, it depends on what kind of juror you can seat 12 people. The judge is going to seat 12 people. The question is how impartial those people are and what kind of questioning you've done for it. I think it's a good point. Good old boys club. You hear that a lot. A lot of people have said that. That sort of seems apt sort of description of it. So, like, if I'm asking a juror, I think it would be important to ask them about that. Anybody think there's a good old boys club here in this part of the Low Country where rich people, whatever, and just have a discussion about that. There's a lot of distrust of the legal system right now. People think rich white people get treated better than others. And, that might be something that you'd want to explore, if you're a rich white guy being accused of a crime. But I don't expect that to be explored with those jurors. I just don't think there's time to go through it.
Wow, time is against them right now. Lindsay Shea here writes, Alex Murdaugh was also involved in a 19-year-old Stephen Smith's mysterious death. Now, this is really the son, Buster Murdaugh, who's a namesake of the same guy who's got the portrait that they had to remove out of the county courthouse. The state police opened a new investigation into the 2015 death of Stephen Smith. He was a 19-year-old man who'd been found along a road about 10 miles from the Murdaugh home and who was thought to have been hit by a truck. The police have not accused anyone of wrongdoing in Mr. Smith's or Miss Satterfield's death. That is the housekeeper. But Tim, to you, I mean, we've got a 19-year-old, and there is talk that the son had some sort of interaction with this Stephen Smith, and he may have killed him. And then there was another comment right here, just to show you the complexity of this case. Again, how do you feel about the boating accident? This goes back to February 2019. A fatal boat crash took the life of a young woman named Mallory Beach when her friend, Paul Murdaugh, the son who was now murdered, allegedly drunkenly crashed his family's boat. In 2021, after Paul was murdered, investigators began to take a closer look at the Murdaugh family. I mean, Tim, how do you begin to even untangle this web? I mean, it's insane. And there's accusations a lot that, because it was a good old boys club, that a lot of this stuff was being, suppressed and hidden. And investigators were told to come up with certain, reasons for why people died. How do you begin to untangle this?
Well, I don't think any of that's going to be admissible in the trial. The boating accident was his son. I think the father's being sued because he probably owned the boat. And then maybe there was some shenanigans about the son, but the shooting of the Smith, or the getting hit by the Smith, they don't have enough to charge him. So you couldn't bring that in as Williams rule, what we called in. It's called 404B evidence in federal court, evidence of other crimes that are consistent, that you use it as a mode of that someone's how they do it all the time. It seems like they just want to bring that in to show bad character, which is clearly not admissible in this case. However, if he testifies, which I don't think he'll testify because he's got way too many skeletons, he'll have to admit to being a fraud, have to admit to being on drugs and stealing, and that's not going to make him look good. The defense is trying to keep all that out, but if he testifies, he opens a Pandora's box. So I do not think he'll testify.
And Tim, if he said to you, listen, I'm an attorney, I'm smart, I know what I'm doing here, let me speak, what would you say to him?
I say, Judge, can we go on the record? And we want to put on a record, Judge, that my client is exercising his right to testify against his attorney's advice, against all of our advice, but he has that right, Judge, and we just want to put on the record so later on he can't come back and say, my lawyer made me testify. And they will do that if they lose.
Interesting. I'm perfectly imperfect. And this, Dan, is for you. The judge will also possibly question them privately in chambers and make his final decision there on keeping them. Is that true?
I have no idea. I'm not sure if that's the way they do it. It was not going to be done privately. I can tell you that. No, there'll be a court reporter there. The lawyers will be there.
And the defendant.
But
so going back to what we're talking about, the sort of these other issues, I think is really, regardless of whether the stuff comes in, all these other issues are out there, and it's you got to be careful when you're defending a case like this that you sort of stay on track and stay on theme, and you don't just turn it into a case of the yeah buts where everything is a yeah but, because there's just sort of a cumulative effect that these things will start to have. And in order to win a case like this, you have to have jurors that will keep an open mind throughout, at least throughout the end of the prosecution's case and into the defense case. And it's kind of hard to do that when there's, all these things, these fraud and these other things. I got a little different take than Tim. I think probably his only chance of really getting a good result here is to testify. But again, that's the difference between a legal opinion and a jury consultant opinion. You should probably listen to your
Dan,
lawyer.
Why do you think that, Dan? I
just think there's too much skepticism and distrust if a defendant doesn't testify. I mean, listen, I wouldn't do it if you don't have to, right? If you feel like when the prosecution is done, if you feel like they haven't done it and you feel like we don't need to, I wouldn't do it. But I don't think we're going to be at that position in this case based on what I've read. And so, that's what jurors want to hear, what he has to say for himself, and I think if jurors are going to say, if you're going to have me sit here for 3 weeks and you're not even going to speak for yourself, and you're not even going to tell us what happened, why'd you have, if it's not human blood, why do you have non-human blood, high velocity on your shirt? How about that? So he is going to have, I think he is going to have to somehow connect with jurors where they think that this prosecution is overbroad, and full of holes, and it's going to, I think, kind of have to come from him.
I disagree. I think he's got such a charismatic, smart lawyer in that community that I don't know if they think a not guilty is a victory. I think they think if they get a hung jury, it's a victory.
Oh, yeah. Oh, I would be a victory. I would agree with that.
As a defendant gets up there, as you know, and our defendant did testify. He testified for 3 days on the stand. That defendant makes a bad move. All the jury selection in the world,
yeah,
not going to fix the problem.
Yeah, I'm not saying I'm not saying it doesn't have risks.
I've seen it go both ways.
Yeah.
Dan, this is for you. This is kind of a question, just hypothetical out here. LK writes, how would you strategize or negotiate voir dire in a case with several co-defendants? I had a federal case where there were 10 co-defendants, and we had to collectively agree with counsel to the strikes. That's not really relevant to this per se, but if you want to take a shot at answering it, I think it's interesting.
Well, you shouldn't have to share your strikes.
You do. You do, Dan. In federal, you'll get a certain amount of strikes depending, and they'll give you extra strikes if you have multiple defendants.
Yeah, well, that's what I mean. Like each defendant will get 3 peremptories or whatever it is, right?
Not getting that many. But usually what you would do is you have one lead lawyer, the lead defendant. You'd work on an agreement. Everybody has input, but we have to come up what's best for everybody. It's not easy to do it. I can imagine 11 lawyers is really difficult. Really difficult.
Yeah, because a juror may be good for one defendant and bad for another.
Exactly.
Yeah.
It sounds super complicated. As if this case wasn't weird enough, then we've got a guy named Curtis Edward Smith. He's a distant cousin of Alex Murdaugh. Murdaugh at one point claimed that he'd been shot in the head on the side of a rural road by somebody who drove by while he was alone, changing a flat tire. He was taken to a hospital. His story soon began to fall apart. And then it turns out it was this distant cousin. I guess that was your cousin Eddie reference there, Tim. So this story, man, it is much stranger than fiction. To this comment here, Tim, from YT3, I think the boating accident was the catalyst for the murders of the wife and son. A financial hearing was scheduled within 48 hours. The true state of his finances were going to be revealed. We just had Detective Phil Waters. He's investigated over 400 homicides, and he says that you kill for money, love, and now I'm forgetting the third, but it'll come to me. But is this a case of money?
Yeah.
Is it? Well, that's one of the reasons that stuff may come in, Tim.
No, I agree. I agree. This would come in. And if I'm the prosecution, I said, Judge, he isn't being sued for his conduct. He's being sued because he owned the boat. And he was going to have to, and they might be able to argue, Judge, that goes to motive. He had a financial reason. The timing of the killing is really relevant, and we think it should come in. And depending on the state's physical evidence, if they don't have a lot of physical evidence, the judges lean that way if they think they need it to get a conviction. If they don't need it and it's just piling on, the judge is not going to let it in because that's a chance to get overturned. So the prosecutor is going to have to really make his case that, Judge, we really need it to prove his motive.
And Dan, I mean, this is another issue with this case, the comment we're about to read from Patty G. Maybe the trial is going to be somehow rigged, so there's an acquittal. Judge is part of the powerful people in the county and court system. No matter how this trial plays out, particularly, though, I guess, if there is an acquittal, will people just say, hey, he was just part of the, the good old boys club and it was just a setup? this isn't really a jury consultant question, just a question to you about the fact that this, once again, is in a, small county in South Carolina.
Well, I think that would be the narrative if he gets acquitted, at least from some sectors. I mean, I think that would be, people have said that for time immemorial. I think, there's my jury data has shown a really sharp uptick in distrust of the judicial system, much more pervasive. It's no longer sort of an outlier, kooky, type thing. And it's not a right wing, left thing. It's one of those weird things where even people on the far right and the far left, they agree for different reasons. So there is a lot of skepticism. There is a lot of distrust. Again, that's one of the reasons as a jury consultant, I would want to ask jurors about that, because if you have a juror who does think that, maybe they're more inclined to send a message by, finding this guy guilty. Right. So, I mean, that's just that narrative is so pervasive in the area that I think it merits questioning jurors about it. But I would bet you that they're not.
You look at the judge too in this case. You don't have a good old boy judge. You have a minority judge who came from very poor background, put himself up, lived in a really small area, and had to take a job in this small area because of segregation. He's not going to certainly allow the good old boy network to run his courtroom. Not at all.
That's an interesting point. His name is Judge Clifton Newman. Dan, to you, we did this last night, which is why I put it in the comment section from Smashley. Will Alec Baldwin have a difficult time finding a jury? Tim was talking about Alec Baldwin last night. We've got you here tonight. So what do you think? Is it going to be tough if it goes to trial? Will it be tough to seat a jury for A-list celebrity?
Well, first of all, I think that thing going to trial, it's way premature to talk about that case going to trial. But they have the same concerns that they have here, people wanting to get on the jury. And so that's something that they're going to have to be on the lookout for. But let's be very honest. It is very clear that celebrities and people that have high name recognition, almost without exception, get treated better by juries than people that don't have any name recognition. There is a certain degree of sort of whether you call it hero worship or whatever. People that are well known, in our culture, that's just it's important to be well known. So I think those people fare a lot better, and any of the complaining and whining is undeserved.
This next question is from a friend of the podcast, Perpetua Sridharan. Sorry for butchering your name if I did. Can a truly fair jury panel be selected in this day and age, Dan? With the media and all the podcasts related to true crime, is there a chance a jury has never heard of a case or defendant? Not now with Surviving the Survivor, because the whole world knows about us, but prior to Surviving the Survivor, Dan, if you could respond to the question.
Yeah, again, you're not looking for people that are ignorant. That's not the objective. Ignorance is not being fair. Ignorance, not knowing anything about a case, not hearing anything is not, one of the metrics that goes into determining fairness. And I guess the bigger question, and not to wax philosophical, but what do you mean by fair? Fair to whom? Somebody.
That's a great question.
Let's be honest. When I'm hired to pick a jury, I'm not looking for a fair jury. Okay, I have no interest in a fair jury. I want a jury that is biased in favor of my client. That's what I want to do. Do I get that? And hardly never. Really what you do end up with, this is a battle over the middle. The very strong personalities, the outlier personalities will be struck, and you'll be left with sort of a group in the middle that didn't say anything that was offensive enough to anybody to get them struck.
Dan, would the framers of the Constitution have a heart attack knowing that you make your living off of doing what you do when you are transparently saying you're not looking for, you're looking for a slanted jury.
Yeah, I mean, I in my own sort of personal journey in this work, I've had some very, very serious, ethical qualms because, quite frankly, it works. I mean, we win far more cases than we lose, and we rarely lose without knowing that we're going to lose. It's not rocket science. If you want to know how your case is perceived and you want to know what kind of jurors you want, there is a path to figuring that out. It just costs money. And I remember talking to a mentor about this and saying, it is an absolute unfair advantage to somebody that can afford it. There's just no question about it. But the same thing is true of being able to hire Tim Jansen versus Joe Schmo. Okay, if you don't think that that's an advantage to have a lawyer like Tim Jansen, then you don't know what you're talking about. That's an unfair advantage if you compare it to just getting some schmo from the Yellow Pages. It's just not even close. So fairness to me is sort of a nebulous concept. I don't go in for fairness. I go in to win. That was our logo for a long time. Percy Foreman, the great lawyer, that was his quote. As he says, when you're in a lawsuit, you're not trying to achieve some abstract notion of of justice or fairness. You're trying to win.
Yeah, your clients don't hire you to try; they hire you to win.
That's it. That's what America is, about winning and losing. Let's look at some of the meat and potatoes of the case. I know Dan's got to run in a few minutes, so we'll take a few more and get some closing arguments, as I like to say. But 503 decal, Tim, to you, do you think the prosecutor will bring up Alex's money crimes during opening statement, which bleeds into this, no pun intended, but I guess there is, to Coop 3000, admit what into evidence? There's no shirt. Who other than the state lost it? No judge is going to let them talk about it anyways. And it goes on and on. There was another comment. Is this case all circumstantial evidence? I don't know. Where do you start here from the defense side, since that's where you'd be looking at it from? And then I guess from the prosecution side. All
right. So on the defense side, of course, I don't want the finances come in because it's detrimental to our clients' case. It's only about bad character. There's no evidence that his finances had anything to do with someone killing his family. The shirt should not come in. They lost the shirt. They can't say it even has human blood on it. So the relevance is really zero. Confusing. Whether or not they'll let it in the opening statement is questionable, because what happens is judges say, okay, we got this issue or these issues. I'm going to wait. I'm going to reserve ruling. And I don't want you to mention an opening statement. I want to hear some of the testimony in the case, and then I'll give a ruling. But for right now, neither party is allowed to talk about the shirt. Neither can talk about the finances. They do that all the time. And
this is why you don't want to be a defendant, people, really. This is why you don't want to be a defendant in federal court.
Right. And on a prosecution side, judge, the jury is entitled to know what his motive was. We don't need to prove motive. But the timing and the finances, it led to what he did. We think it's relevant. It puts our case together. The shirt, Your Honor, we had people look at it. We can't explain how we lost it, but it was tested. We think it would help the jury. The judge is going to make those are tough decisions. Defense is going to fight them like hard, and that could be enough to reverse a conviction if the judge is wrong.
Dan, to you, listen to learn. My guess, the jury will be hung 50% like the guy, 50% will hate him. I think you could say that about Alec Baldwin, not necessarily Brian Kohberger in Idaho, because I think pretty much everyone hates that guy. But can you even postulate on this yet about a hung jury when the jury hasn't even been selected?
Yeah, I think it's a likely eventuality for a number of reasons. One is that we have seen in our jury research, and just I think people can see it just culturally when you look around, a tremendous reluctance to compromise on really anything. It's almost seen as a weakness, giving in to your enemies, et cetera. So we have seen more hung juries in our mock testing over the last 24 months than at any other point in my career. People just dig their heels in, refuse to compromise with their fellow jurors. So I think because we are so polarized culturally and politically as a country, I think that's does set up that likely possibility. And then second of all, if absent anything else, in this case, if I were hired to be the jury consultant for the defense, I would try to hang this jury. I would try to, put a couple, antagonistic personality types together, put people on the jury that are going to hate each other and argue and fight. Whatever you can do to kind of throw a wrench in there. And try and inject some doubt and hopefully not, I would assume they have to be unanimous on a death penalty case, or they're not seeking the death penalty, are they? But
it's still unanimous.
Does it still have to be unanimous? Probably yes. Still does. Okay. Yeah. So yeah, I mean, that's the low hanging fruit, is just try to put together find some people that are, competitive, and put them into the mix. Would be I would think it'd be a perfectly cromulent strategy from the defense side. So that's two reasons why I think that's probably we could definitely see that happening.
M. Schmidt writes, the Murdaugh family has steamrolled the entire law enforcement community, top to bottom, judges, etc. Tim, does this make it tough to prosecute this case because you're really, part of that family, if it is in fact true?
Well, I think that is true. And I think in small towns, when your family runs law enforcement, you pretty much run the town. If you run the court system and your family's affluent, you're going to have a certain amount of respect. You're going to have people grow up into these positions that got them from you or friends or something. So there is going to be some allegiance to the family. It sounds like this is nothing but a circumstantial case, which is not bad, but it's a little harder when you have circumstantial evidence. Cousin Eddie could really make an important part of this case, because if they can show that he's tried to commit insurance fraud, and that he's capable of doing this, that the jurors might have second guess about this guy's credibility. But if you're right, people are going to like him or they're going to hate him. And
well, the point that you're making about this, them running the judicial system and they're so entrenched, that's all the more reason why the court should be allowing for more voir dire and more inquiry of these jurors, so that we don't get to the end of this thing and we say, well, man, we didn't even really get to hear from any of these jurors. The judge just kind of, skipped through that part. If people want to see justice done here and they want to see the right thing done, you got to make sure there aren't any questions about any part of the process. So, if I were the defense, I mean, I'd be banging that hammer nonstop. I know it's tough because you don't want to anger the judge. I get that. I get that, but you got to speak to the record. You got to be aggressive, and you just got to fight like hell. At this stage, I think start making your record, for appeal. This part of the case is the jury selection part is every bit as adversarial as opening or closing as anything else.
I think that experienced lawyer is 74 years old. He's not really worried about being friendly with the judge. Any lawyer in that courtroom knows it's the judge's courtroom, and it's your job. You don't tell the judge this. It's your job to make that your courtroom for your client. And the judges know that. Prosecutors, not so much, but the defense lawyer, you have to make that jury believe this is his courtroom. When you stand up and you start getting ready to cross-examine, they have to be on the edge of their seats, knowing that this guy's going to put a hole in this story. And if you don't fight for your clients, you're just, we call them V6s, violation of the Sixth Amendment. The lawyers that just roll over, don't fight. There's a saying, if you don't get close to being in contempt, you're not arguing enough for your client. But you have to ethically do it, but you do have to fight for your client. And I think this experienced lawyer is going to do that. He's not going to be worried about his reputation.
I'm going to get a law degree from the Tim Jansen School of Law by the time this is all said and done. T. Hang, she writes, we had Alec, Brian. Wow. We also had Brian Laundrie before Brian Koberger. And who's the other Brian? Brian Walsh in Massachusetts. And it is kind of wild that someone else pointed out that some of these names do go in groups of three. We'll see if there's another Alec that gets in trouble. To you, Dan, from Coop 3000, isn't the critical issue that there's no longer a Murdaugh left in the world to be afraid of? This is the nail in the coffin on that thread of corruption. Juries hate rule breakers. Is that true? Do juries hate rule breakers?
I mean, I guess it depends. I think in general, yes. It's all depends on what their expectations are. To me, going back to this whole good old boys network thing, my experience is that the legal system does actually a pretty good job of self-policing itself, and does aggressively go after bad actors. So, I maybe even with a little more enthusiasm than they would go after a non-lawyer, in fact. So I think this guy may get treated a little more harshly rather than less harshly, at least at this stage. He might have been part of the good old boys network before, but he isn't anymore.
You hear that, Alex Murdaugh? No more. Perpetua writes, and this is why she's a friend of the show. Thank you, Joel, for spectacular shows that are thought-provoking and just so intelligent. That's because we have the best guests in the business. I never miss a show, and you're going to be busy the next few weeks because we're going to be covering this Alex Murdaugh trial from start to finish, and yours truly might end up in South Carolina for closing arguments. Maybe I'll drag Tim with me.
Love to.
Yeah, let's do it. Tim Jansen is, as you just saw, is the creme de la creme of criminal defense attorneys. He also spent 5 years as a federal prosecutor. If you're in trouble, you better look him up on the Google and find him and get a hold of him. Hopefully you're not in that kind of trouble. Tim, what is the defense team doing tonight and the next couple of days?
Well, I'm sure they're splitting things up. They've got parts of the team doing motions, preliminary motions. They've got someone going over the opening statements. And then they have probably, if they're smart, like they should, getting the names of the people that are on the potential juror, doing background, doing social checks on them, seeing what magazines, seeing what they post, so you can get an idea of who these people are, because social media and their footprint on social media, it'll give you more than the questions you're getting from the judge. So they're probably got somebody going on social media, Instagram, whatever, looking at these people's posts and seeing the 35 that have already been cleared. Now, I don't know if the judge gave them the whole list, which Dan and I tried to get in our federal trial. We wanted all the jury pool beforehand, but we were too afraid to ask the judge. But if they got the whole list, they should have people working through the night doing all the social media checking on these people to get an idea of who they really are and then targeting them for their jury.
Dan Wobold Jr. is a veteran trial strategist and jury consultant. He's the founder and CEO of Best Evidence, which is the jury consulting firm of choice for guys like Tim Jansen, who's a criminal defense attorney. That's an interesting point that Tim just raised. Are you looking, Dan, at these social media profiles tonight to see what kind of information you can garner from them? And also, what ends up happening with this, the seating of this jury in this quote unquote trial of the century in South Carolina?
Well, I think Tim is almost surely correct that they have somebody that is looking into the jurors and looking into their background. So some sort of private investigator that has access, probably former law enforcement. Obviously I've been involved in that process many times. I don't think I've ever found it to be useful. It's too much information And there'll be many people you will have nothing on. You will have an empty dossier. They do not have Facebook. They do not have Twitter. They do not, or they do and they don't post, or they do and they just post cats. You know, so what have you learned? You've learned nothing. You've wasted your time. So I think most of this stuff, we tend to get paralysis by over-analysis, you know, is a term. So I like to just have an understanding, like I say, what are my data points? What am I looking for? Who am I looking to avoid and exclude? And let's not get distracted by this other stuff and other data that we can get that we don't know what it means, where that stuff becomes useful. And how it could potentially be useful, even if you knew it up front, is after the trial. So when you're going back and you look and you say, hey, wait, this juror said that they had never had any litigation, and here they got 3 personal injury cases. They lied in their jury selection. So that's the kind of, you can get that sort of advantage, but I think it really only comes into play after, you know, looking backwards. I don't think there's enough time. They have so many jurors, they're literally going to get a report about that thick for all the jurors. I've seen them, we've done them. And it's just, you go through and it's, you know, it shows, you know, publicly available information, and it's usually not very helpful.
Tim, is there a conviction in this case or no?
I think the state's going to have a hard time getting a conviction if the T-shirt is kept out. And I say that because I think the T-shirt should be kept out. If the finances get in and Cousin Eddie does good for the state, I still think they're going to have a hard time convincing 12 in that community to convict.
And Dan, same last final question to you from the jury standpoint. Will there be a conviction?
Yeah, tough to not have the murder weapon. That's I think that's very significant.
And there's actually 2 of them in this case.
Right.
They need 2 different weapons.
Right. And yeah, so I think, again, it all depends on how these other bits of evidence come into evidence and whether or not they do. Again, it gets to be a cumulative thing where if you keep piling on all this fraud and deceit and whatnot, and I do think the prosecutors are going to tie that in with motive and show we need to show this because we need to show how desperate he was. So I wouldn't be surprised if it comes in and man, after, you know, a week and a half or 2 weeks of getting pounded over the head with that, you know, if you still got jurors left that got, got even one ear open to the defense, I think you're going to be lucky. So it's going to be a tough case. I understand. I don't know the defense attorneys, but I understand they're very good.
Don't underestimate a good defense attorney.
And yeah, never do that. I would never do that. Kathleen Elliott writes here, it's not up on the screen. They named approximately 240 witnesses. Get your notebooks ready. I'm going on record as saying there's no way in hell this is ending February 17th, being that today is January 23rd. It's not happening. It's going longer than 3 weeks. About a conviction, I'll leave it to these guys, the experts. Final comment, the best panel ever. I've said it once. I'll say it a million more times. We've got the best guests in true crime. You guys need to hashtag that out. Best guests. Huge thanks to Tim Jansen and to Dan Wolbert. Dan, you need to come back. Will you make that promise live right now?
Sure. Love to.
Awesome. Thank you, everybody. Love you, America. Till next time.
See you, Tim.
Bye-bye. See you, Dan.
Bye, guys.
Oh, he bounced out already. Okay.